Master case from date is 1907, second has to be 81 of 2022. Master case item 13, second has to be 127 of 2022.
This is the appeal by the plaintiff. He was lost from the court.
What was the suit for?
Suit for declaration of right to interest over the suit and also for recovery of possession. The case of the plaintiff was that the suit land was originally belonging to the Saraikela state. In the year 1945, by a patta hukumnama, it was given to the petitioner on the salami of rupees 500. Subsequently, in the year 1964, when survey was made, then in the record of right, name of state of Bihar was entered, but he could not get it corrected. Subsequently, in the recent survey, in the year 1983, again name of state of Bihar was recorded, but in the position column, the name of the petitioner appeared. But position was shown from 1996. He filed an application under Section 90 of CNT Act. Correction was made, and nature of land was recorded at Makan 7 Bari land. House and field was recorded. That has never been challenged, that has been finalized. Subsequently, in the year 1999, there was an encroachment right. The respondent state tried to evict the petitioner. He approached this honorable court by filing a writ petition. Direction was given that he approach deputy commissioner. He went there, his representation was rejected, and thereafter he filed the present suit. His case was that even presuming from 1960, more than 30 years he has remained in continuous, uninterrupted position. That is evident from their own record, from the record of rights. So I have perfected my right title and interest. I have brought on record 4 documents. Firstly, the patta which was given by the Raja of Saraikela, rent receipt which was issued at that point of time. Khatiyan I have brought on record in which my possession is mentioned since 1960, and the audit which has been passed under Section 90. Now, respondents filed their written statement. They admitted that land was originally belonging to the Saraikela state, but they stated that after BLR Act coming into effect, land vested with the state of Bihar. However, no document of vesting was brought on.
What was the document of vesting required?
The document stating that this particular plot of land has also vested with the that is
like this. The entire land vests and the zamindar files returns. And
So
saying that this is my property, this will vest, this is my. There are various forms which are filed. There is no doubt that everything vests, because by virtue of abolition of zamindari completely goes away. But there are certain personal property of the zamindar which is retained by him, and there are certain properties which are lying with the tenants. Those are retained by the tenants, and rest of the property is straight away vests with the state. This is the law. So they were not supposed to prove that it vested. You were supposed to prove that this particular property continued in your possession, and it was mentioned in the zamindar.
For that, I have brought on record the patta and the rent receipt which was issued by the erstwhile state.
Is there any rent receipt issued by the collector immediately after vesting?
No, that is not there on record. Had it been there on record, then it could have been. But my case is that patta followed by rent receipt and followed by continuous possession of more than 30 years.
That is not. That will not confer title on you.
And from even on
You are seeking adverse possession, or you are seeking title, or you are seeking both.
my case was based on both.
Is it not inconsistent?
It is inconsistent. I cannot develop that emotion because The statement was that plaintiff has already perfected his right title in interest over the suit land, which he had acquired in the year 1945 from the ruler of Saraikela state, and continuing his uninterrupted peaceful possession since then. So that is the statement which has been made.
So you,
No specific
so
statement.
you are claiming what? You are claiming adverse possession or
Right
you are
title and
claiming
interest
title?
over the land in question. On the basis of patta followed by rent receipt and
So you are claiming title over the land by virtue of patta.
patta.
So how do you claim adverse possession simultaneously?
Uninterrupted possession since more than 30 years it is there.
Is it not? What?
And my possession is recorded in the record of right itself.
Entry in record of right will confer title.
But the learned trial court has also held the 1964 record of right that has been considered to be true, and it stated that
True means what? You were found in possession. Simple. That is true means this only. That you were found in possession.
and my possession along with my house and field has been found to be there since 1960.
Illegal possession.
Possession has been held to be illegal.
No, in the record also it is illegal possession.
In the record.
In the record of right also there is a caveat. It is illegal possession.
Illegal possession.
So you cannot say that without any interruption, without any cloud in your title, you continued in uninterrupted possession.
No, because it was within the knowledge of
Maybe within the knowledge.
Within the knowledge.
But the
and
fact is that it is
nobody
illegal.
even tried to take any reports of law to evict me from the possession in question. So since 1960, I have continuation possession. My patta has not been disregarded that it was a forged document, or my rent receipt has not been disregarded. Appellate court has held that it was not issued by a competent authority. That is the
Because the patta was not issued by a
competent authority. Although that was not the issue and no question was raised by either side that whether it was issued by a competent
The
authority.
state was a party.
The state was a party.
State filed their written statement.
They filed.
So your contention is that patta was executed by whom?
By the Raja of Saraikela.
Registered.
Registered no.
Not registered.
Exhibit.
What is the date of patta?
April 1945.
Bihar Land Reforms Act. Rent receipt from which date? Rent receipt is from which date? What is the oldest rent receipt you have? Date.
One is of 30th 4 1945.
You read it from the judgment. Don't read it from your document.
Marked exhibit has been stated, but the date of rent receipt is not. The original was in Odia language.
Where is the finding of the learned child?
Starts from page, internal page 8, running page number 17. Paragraph 12.
Yes. Internal page
8.
You come to internal page 12 for a moment.
Yes.
On the basis of
On
above
the
discussion.
basis of our discussion, I find out that the Sood land was originally Allahabad, Mali, and of rural erstwhile Saraikela state, and it duly come under the ownership and possession of state of Bihar, and was rightly recorded in the name of state of Bihar. If there was a Hukunnama Patta in favor of plaintiff, the plaintiff would have filed a petition for fixation of rent after merger of Jamindari of Raja Saraikela into state of Bihar before the proper authority. Further, had there been any such settlement in favor of plaintiff, the CS survey Khatian could have been corrected in the name of plaintiff. It has been raised by the plaintiff that the Sood land was settled by him by the ruler of Saraikela in 1945, but the plaintiff PW admitted in para 33 of his cross-examination that in 1945 he was about 16 to 17 years old. Therefore, he was minor at the time of taking settlement from Raja of Saraikela. Hence, question of settlement during the said year is against the law then prevailing in Saraikela state. The DW1 fully supported the case of the defendant and stated that the Sood land is rightly recorded in the name of state of Bihar in RS survey settlement.
So this finding with regard to Patta, 2 points.
He was.
How do you say minority? How do you defend this? Patta in favor of a minor?
That was not even an issue before that.
Maybe, may not be an issue, but when the legality of Patta is being considered, then these things are
Patta in favor of a minor,
valid.
a contract with a minor would be valid. But a Patta in favor of a, as a beneficiary.
Law did लिखा है. Beneficiary नहीं है ना? Patta is directly in favor of a minor.
There is a judgment launch.
Okay. Just a moment. Grant time for what?
Send it in favor of a minor can be executed if it is
It's
in.
not as who will accept the sale deed on behalf of the minor. There has to be, he has to act through a guardian. We are not saying that there cannot be any sale deed in favor of a minor. It can be. But he has to be represented through a guardian.
My case was that it was not the issue before the court whether at the time when Patta was issued in his favor, he was a minor.
You see, when you are claiming title on the basis of a Patta, every aspect of the Patta is absolutely
But that
exposed.
minority of the plaintiff at that point of time was not even the issue before that.
May not be, but every aspect of the particular document, this has come in evidence that you were a minor, isn't it?
About 16 to 17 years old, that was the statement which has come in cross-examination.
That's right. There was a purpose of cross-examination.
But that has been taken into account for deciding that he was minor at that point. That was not even the issue before that. That was not even the issue before.
What about the appellate court?
Appellate court has.
And the record of right was entered in the name of state of Bihar.
State of Bihar in the year 1964. Subsequently, when recent survey was made, then also it was entered in the name of.
So after vesting, is there any rent receipt in your bill?
No, after resting, it is no rent receipt.
No rent receipt. What about the appellate court?
Appellate court, running page number 56 and 57. Minority has been held, and in page number 57, it has been held. Plaintiff case that
Internal page.
internal page 30. The
30?
plaintiff 30.
No, internal page is not matching. 31.
The plaintiff case base on alleged Hukamnama, and as per Hindi translation of the same, it was executed by Sur Sarpati, not by the ruler who has no title over the Sur property. Thus, this court find that the alleged Hukamnama, Patta Exhibit 3, is not executed by the competent. So, Patta has not been held to be forged or fabricated.
It is not a matter of forgery. Anybody if signs a document, it doesn't become a forged document. If the signature is genuine, then it does not become a forged document.
That is what I'm trying. That is what I'm trying to say. That Patta is held to be that a genuine document, and I have been in possession. My possession has also not been. Nothing has been said regarding that. Only that in the year 1964, record of rights wrote the name of state of Bihar, so a presumption has been put.
Sur Sarpati. Who is Sur Sarpati? Who is Sur Sarpati? He is the Jamindar.
That I cannot say much because that question was never raised even by the defendant. That he is not the Raja of Saraikela, rather he is somebody else.
So you must have stated no that who was the Zamindar, who executed the patta.
I stated that.
Yes, who according to you, who was the person who executed the patta in your favor?
Raja of Saraikela.
Raja means what? Some name.
Name has not been specifically pleaded, but this came for the first time before that by the appellate court. This was not stated by the defendant that he was not the Raja, rather somebody else was. The learned appellate court has on its own stated that he was not there.
Maharaja Aditya Pratap Sindhe was the last ruler of Saraikela state and was also the landlord of Mauza Aditya. This was your specific case before the learned trial court. The appellate court recorded that it was not executed by this Maharaja.
That question was also not, that issue was also not there because neither any issue was framed on this aspect, nor we were.
ऐसे issue थोड़ी frame होता है. When the patta is in cloud, that too an unregistered patta, many aspects of that will be taken care of, isn't it?
The question could have been that whether Sur Sarpati was given an authority by the then ruler or not, that could have been an issue. Then evidence could have been adduced on that aspect. But all of a sudden, this point was raised by the appellate.
Accordingly, the Raja of Saraikela by a hukumnama settled his khas possession of property with the plaintiff, right? And his khas possession of property with the plaintiff also does not get substantiated by any kind of rent receipt issued in your favor immediately upon vesting in terms of the Bihar Land Reforms Act.
That is there. Prior to that, rent receipt is there. That has not been discarded by both the trial court and the appellate. But subsequent to
What about adverse possession? Was it a issue framed?
No, not at all.
If issue was not framed, the
Issue was not
matter
framed.
need not be. It's absolutely conflicting. No issue was framed on adverse possession. Heard the learned counsel appearing on behalf of the applicant. This appeal has been filed against the judgment and decree dated 27/6/2022. Against the judgment dated 27/6/2022, decree signed on 11/7/2022. by learned District Judge Omuntu Salekela Kharsawa entitled Appeal number 17 of 2008, whereby the appeal filed, whereby the appeal has been dismissed. The judgment of the trial court was passed by the learned Munsif Saraikela in title suit number 43/1999/26/2007. ट्रायल कोर्ट का है, जजमेंट डेटेड 39/2008, डिग्री साइन ऑन 10/11/2008. The learned counsel submits that although there are concurrent findings recorded by both the courts, but substantial question of law arise for consideration in this case. He has submitted that the appellant was claiming title on the basis of an unregistered patta executed by Maharaja, executed by the then Jamindar of Saraikela. He has also submitted on 30/4/1945. The learned counsel has further submitted that pursuant to the patta, the ancestor होंगे ना आपके? The ancestor of the plaintiff.
नहीं, original plaintiff. Father Soren was the original plaintiff. Subsequently, he died and his legal heir.
Pursuant to the patta, the original plaintiff started paying rent to Zamindar, and after vesting of the after abolition of Zamindari, he continued to be in possession of the property. The learned counsel has submitted that the in the remarks column of the Khatiyan, the plaintiff was shown to be in possession of the property and there was certain erroneous entry which continued till 1989, and as soon as he came to learn about it, he filed a case under section 90 of Chotanagpur Tenancy Act before the charge officer Sindhu Settlement at Jamshedpur, which was registered as case number 7 of 1989-90, and by the order dated 2/5/1996, the plaintiff was found in possession since 1945. And the class of the land was also corrected as Makan, M-A-K-A-N. Okay, Makan, no, Makan, Sahan and Badi land instead of Purani Parti, which was earlier recorded. He submits that the state order became final. The Learned Council has submitted that ultimately the Learned Council has submitted that the plaintiff was perfected his right, title and interest over the suit land, which he acquired in the year 1945 from the ruler of Saraikela state and continued his uninterrupted peaceful possession since then. He has also submitted that the defendant number 2 and 3 the defendant number 1 who has no right, title and interest over the suit property allowed the defendant number 2 and 3 to act arbitrarily without taking recourse to law to dispossess the plaintiff from the suit land, and which casted a doubt with regard to right, title, interest of the plaintiff, and therefore the plaintiff instituted a suit declaration seeking declaration of his right, title and interest and recovery of past possession of the suit land. When the cause of action arose on 6/4/1999 and the defendants illegally undertook construction over the suit land. The Learned Council has submitted that though it was never the case of the defendants that the executor of the hukumnama was not the then zamindar, still the appellate court, by affirming the judgment of the Learned Trial Court, recorded that the hukumnama, that the case of the plaintiff is based on alleged hukumnama, and as per Hindi translation, the same was executed by Satpati and not by the ruler, who had no title over the property. And on this basis, the appellate court held that the hukumnama Patta Exhibit 3 was not executed by the competent authority. The Learned Council submits that such finding is beyond the readings of the respective parties, and therefore the appellate court has misdirected itself by giving the findings on the basis of which the judgment of the trial court has been upheld. That's all. Arguments of the applicant is concluded. Pose this case for orders on Tuesday. थोड़ा देख के लिखा पड़ेगा। आप state the Learned Council for the state is present. The fifth, sorry, 5 तारीख. 5 तारीख. We'll see. इसीलिए ना देख के लिखना पड़ेगा, ऐसे नहीं कर सकते.
Issue number 3 and 9.
We'll see that.
Then read it together.
जज में नहीं ऑर्डर्स में ना, अगर मान लीजिए सब्सटेंशियल क्वेश्चन ऑफ लॉ होगा तो फ्रेम करेंगे. सब्सटेंशियल क्वेश्चन ऑफ लॉ फ्रेम करने के लिए रेस्पोंडेंट की कोई जरूरत नहीं. You are nobody at this stage.
Yeah, absolutely.
I'll see fix the record देख के ऑर्डर करेंगे. ये फाइल हम घर से नहीं पढ़ते.
Apply. Master case item 7, second appeal 81 of 2022.
क्या नाम है इनका? मिस्टर मनोज कुमार सिन्हा को बता दीजिए, नहीं आएंगे तो आज हम इस केस को डिसमिस कर देंगे. हाइड एंड सीक नहीं चल सकता है ना कोर्ट में. पास ओवर ले लिए उसके बाद घूम रहे इधर उधर. फिर 4:30 बजे आएंगे.
Item 16, item 16, second appeal 230 of 2023.
This is by the plaintiff respondent appellant against the judgment of reversal. Plaintiff filed the suit. The appellant filed the suit for declaration of right title interest and confirmation of possession, and also declaration that the said deed dated 17/1/1972, by which the father of the plaintiffs purchased the property, is a valid and legal document, whereas the subsequent survey of the year 2014 executed for the part of the property in favor of the defendants is illegal. These are the nutshell.
So subsequent sale was a portion of the original.
Portion of the deed which I have purchased,
3.5 this who is the vendor of the subsequent sale?
Natho Singh, there is no dispute. I am coming to that. Natho Singh was the digger heir of the recorded heir. There were two brothers, Natho Singh and Dwarka Singh. Natho Singh having share in the property in the suit land, and Dwarka Singh has also share in the suit.
They are co-sharers.
Co-sharers. So there is no dispute about it. In 1972, 17th January 1972, Natho Singh executed a registered sale deed in favor of other of the appellants for an area of 70. Then we got our name mutated, paying rent. We are in possession of constructed house, residing. In 2014, that is after 58 years, 38 plus 40, for 52 years, another deed in 2014 was executed by Jharkhand for 3.5 years. When the crowd created, then the suit was brought in 2014.
You saw this particular 1972 deed was with respect to the entire property.
Part of the property.
Half portion.
Half selling cover.
What was the total area of the property?
Total area I could not find when we speaking. That is the one of the points which I have to raise before you are seeing. Now, in this regard, if you are seeing, kindly permit me to refer paragraph 25 of the draft judgment first, paragraph 25.
Yes.
At page number, page number 23. The plaintiffs have duly proved exhibit 4 that the land in question and other lands had been recorded in the name of Himraj Pandey, Gordhan Pandey, etc. They have also proved that the suit land and other land came in share of Natho Singh in partition between Natho Singh and his brother Dwarka Singh by exhibit 3, and said Natho Singh out of his share transferred the suit land in the name of Jagomar, father of the plaintiffs, by exhibit 1 by Satrayabhar. And after opening of mutation number 29/1981, land receipts were accordingly issued and the same have been exhibited Exhibit 2 series. All the witnesses have also categorically stated and supported the claim of the plaintiffs and the documents as discussed above. On the other hand, the defendants have only produced and proved the sale deed dated of 2014, which has already been exhibited by the plaintiffs as Exhibit 1 by A. But there is no any rent receipt issued either in the name of defendant number 1 or defendant number 2. And hence it is well established and proved that the sale deed number 328, that is 17/1/1972 is valid document. And the sale deed number 4743 dated 24/9/2014 is a fake and false document executed without any basis. It is also proved that the plaintiffs have valid cause of action and SPC numbers.
So whatever was sold to the plaintiffs,
That
according to
cannot
the
be resold.
findings,
That could not have been resold in
according to the
2014.
findings, whatever has been sold by the plaintiff came in the share of the plaintiff.
Nathos.
Nothing. Who is your vendor?
Yeah, who is my?
What happened in the appellate court?
No, because in the kindly come to the appellate court.
Was there any plea of the defendant that there was no partition?
No, they are admitting.
Partition is
They
admitted.
say that it was in the share of Dharikasi. So whatever may be, if I put a question to myself, in 1972, Nathos Singh wrongly sold the share of Dharikasi. So what will be the remedy? Remedy to get the sale deed cancelled, and thereafter their 2014 deed could be valid. If I put a question to myself, that if the Nathos Singh wrongly or
He
erroneous,
sold the entire property. साथ में पहले इसका तो कितना था?
7 डिसमिल करेंगे.
Exhibit 4
Yes.
ये
Exhibit 4 is the Khatiyan.
खतियान. Okay. Nathos Singh sold how much?
7.
7 display.
Only 7.
Exhibit 3 7 display.
Exhibit 1.
Exhibit 1 is 7 display.
Yes.
7 display.
Yes. Exhibit 1 by A.
And
Exhibit 2 हमारा 1
उनका
by A.
sale deed is 3.5 display.
3.5.
Out of this 7 display.
Yes.
Okay. What happened in the appellate?
Yes. Now I am coming to the finding report.
The appellate court has reversed the finding.
Yes. Para 30. Yes, sir. Para 70. 70. It starts at page number 70. I have gone through the sale deed
Just a
of
moment. Just page number 17.
नीचे लिखा है.
Yes.
I have gone through the sale deed of plaintiff father, which is Exhibit 1, petition dated, partition dated 13/6/1979, Exhibit 3. These two documents are considered by the court, and the Learned Trial Court has considered that property was partitioned and paid in the share of Nathos Singh. From the perusal of the sale deed, which is Exhibit 1, it is apparent that nowhere it is mentioned that the suit land paid in the share of Nathos Singh by virtue of any partition, and from the perusal of the alleged partition deed, it is apparent that there is no mentioning of the suit land. Learned counsel for the respondents in reply to the query of this court has stated that as the suit land was sold prior to the partition, hence there is no detail of the suit land is mentioned in the partition deed. Obviously, partition in 1979, sale deed is 72.
Mutation in 80-81.
80-81, sale deed to 72 में था. Partition was 79. It is not in dispute that the mutation of the plaintiff for the suit land is handy. From the perusal of the oral evidence of both sides, it is apparent that the plaintiffs and the defendants both are claiming their possession of the suit land. The fate of the plaintiff's case is dependent upon the right and title of Nathos Singh to execute sale deed of the year 1972. From the perusal of Exhibit 4, it is apparent that the Switzerland, along with other lands, is recorded in the name of three brothers. And as per the plaintiff's case, partition took place in 1979. And in the said deed, there is no whisper about this Switzerland or its haka or festa. It is very strange. 79 में पार्टीशन हो रहा है तो सेम डीड में जो बेच चुके हैं वो प्लॉट कहाँ से रहा? The total area of 145 is 2859 is 70 feet. As out of three brothers, one brother died in Suez. Hence, branch of two brothers got half and half share in the property unless any specific partition took place among the branches of the two brothers. The plaintiffs have brought this sale deed executed by the defendant number 1 in the year 1994, showing that there is prior partition and parties are dealing separately with the land. It is not in dispute that the execution of sale by parties is sometimes showing separation, but it is not in conclusive proof of partition. In this case, the sale deed of the plaintiff is of the year 1972, whereas the sale deed of the defendant, Exhibit 1 by B, is of the year 1994. And as per the plaintiff's case, the plaintiff took place in partition took place in 1979. Hence, this sale deed will not help the plaintiff in proving the partition. In this case, the lender of the plaintiff has executed sale deed with respect to 7 decision of land haka number 145.2859. The learned trial court has given finding that Nathu Singh got Switzerland by virtue of partition, but I do not find any such document on record by which Nathu Singh got authority to execute sale deed for the entire area of the Switzerland. Although mutation is created in favor of the plaintiff's father, but it is well settled that entry in the revenue record nor created any right. The burden to prove is lie on the shoulder of the plaintiff, but he has not brought any cogent evidence which will show that Nathu Singh got authority to execute sale deed.
You claimed partition and then sale,
In the
as per your claim.
oral partition that was followed in 1979.
So therefore, you were bound to prove your partition.
Partition between the vendors, not by me. I am the subsequent purchase. There is no doubt about the fact that Nathu Singh and Dwarika Singh were the two brothers. तीन भाई थे, एक इशूलेस मर गए, तो दोनों भाई हैं. तो प्रॉपर्टी तो और भी है जिसमें शेयर है. अगर शेयर डिफाइंड नहीं अगर बेचे हैं तो सेक्शन 44 of the TPF protects the right.
Schedule B is what? Schedule B properties.
इसमें उनका
एक
डिफेंडेंट है.
Schedule A क्या है?
शेड्यूल है मेरा 7 डिसीजन प्लेंटिफ का. शेड्यूल बी है 3.5 डिसीजन जो उनका 2014 का शेड्यूल है और मेरा 72 का शेड्यूल है पहले का.
नहीं, Schedule B is the entire property.
शेड्यूल बी 3.5 डिसीजन डिग्री में मौजूद दिया शेड्यूल. If you also may can see the trial court degree, last problem of degree, last problem. Last page rather. Degree of the trial. हाथ से लिखा.
हाँ, बाद में करेंगे.
उसके ऊपर मेमो पब्लिक का लास्ट.
Memo का last page तो वकालतनामा है.
उसके ठीक
उसके ठीक ऊपर जजमेंट खत्म. Degree in original suit.
yes, degree in original suit का लास्ट पेज you find schedule A हाथ से लिखा हुआ पेज नंबर 4.
हाँ, Schedule A.
Schedule A, full description of the properties purchased by Jibu Mahan, father of the plaintiff, from Nathu Singh, height 17, number such and such, dated
So
17.
7.
7.
This
Probably आता भी
आगे Schedule B.
Schedule B, suit land. Full description of the suit properties sold by Dwarika Singh to Vikas Kumar Singh by registered sale deed number such and such, dated 24/9/2014 of village such and such, 3.5. This is Schedule B, which is the suit land.
You see, your specific case was that it was recorded in the name of three persons. Hemraj, Govardhan and Khemraj.
They are the original recorded.
Yes. One of the recorded tenant, namely Natho Singh, got his share on the basis of mutual partition from his co-sharer.
Yes.
What is the evidence on this? Is it mentioned in the sale deed? Not mentioned.
Because there is no dispute with regard to the fact. Natho Singh and Dwarka Singh and another brother died issueless. So two brothers remained as a person. Entire property, not this suit land, entire property, other lands.
No, it is specifically with respect to suit property. You see, in short is that the suit land particularly mentioned in Schedule B of the suit was recorded in the name of three persons. It is only in connection with Schedule A property.
Schedule A is 70.
It was joint property of two persons.
But
ऐसा तो कोई केस ही नहीं है कि इसके अलावा भी कोई प्रॉपर्टी
ये सर उसका and other lands लिखी है.
नहीं लिखा।
हाँ, कोड भी लिखा है.
That was not your case. Para number 3 पढ़िए.
Para 3.
Appellate court judge.
जी जी. Para 3. The plaintiff's question saw that Schedule B of the suit was recorded in the name of ancestor in the cadastral survey record. The same has been mentioned in detail Schedule A of the deed that one of the recorded tenant, namely Natho Singh, got his share on the basis of mutual partition from his co-sharer, and he was in the urgent need of money, and he agreed to sell 70 still of land, Khata number 122. Hence, he requested Dwarka Singh to purchase the land of his share on the right, but he did not agree. And thereafter, Natho Singh requested Jibu Mahato, the plaintiff's father, to purchase the 70 still of land. Then Jibu Mahato arranged the 100 rupees and thereafter agreed to purchase the aforesaid land, and 70 still was transferred in the name of Jibu Mahato by said Natho Singh by registered sale deed dated 17/1/1972. After getting full consideration money, the said sale 7 dismissal land was bounded such and he came in, Jibu Mahato came into full possession over his purchased land along with his son. That Dwarka Singh had full knowledge about the sale of land by said Natho Singh of his share. And Dwarka Singh has also sold land of his share in खाता number 145.
ऐसा नहीं है कहीं भी कि इसके अलावा भी कोई प्रॉपर्टी. This was the only property and both of them were co-sharers.
खाता 145 है ठीक है ऐसा नहीं. Then I will permitted to put a question to ask. In any case, our sale deed has been executed by Natho Singh, who is not a stranger. Then in 1972, earlier in point of time, and their sale deed is of the year 2014 by Dwarka Singh. Even I presume for a moment that he has a right. Then the remedy would have been if somebody has sold in excess area, then what he has, which is not his share. This is the case of the defendant. This is not in his share, and that has been sold.
But there is substantial question of law बताइए कौन सा है?
Properly नहीं कर पाए.
It was decreed in terms of the relief rate for.
Yes, it was dismissed.
The suit was dismissed.
Suit was dismissed. It was confirmed by the appellate court. No issue as such was framed. Only two issues have been clubbed together and those that have been decided by the appellate court. Point for determination has been quoted by the appellate court will also be finally ground. Paragraph 10 at page 12. Whether the plaintiffs got right
The
type.
subsequent sale deed has been declared as void.
Subsequent sale deed was declared to be valid, and now my sale deed is declared to be that I did not acquire any right. फिर सूट में तो हमको रिवर्स कर दिया, सूट में तो डिग्री हो गया।
अच्छा, appellate court reverse कर
appellate court रिवर्स कर दिया, लेकिन कुछ डिग्री में concluding part में देखा है। That is at page 18, para 18. On consideration of the above mentioned fact, I am of the view that Learned Jharkhand has only decreed the suit, passed the judgment, original suit number such and such is hereby set aside. No declaration in any way. Only that the Learned Appellate Court, the trial court has findings of the Learned Trial Court is erroneous and has wrongly decreed the suit. So the perverse finding to the effect that we have produced this sale deed of the year 1972, mutation order, rent receipt, following the title, and we are in possession. And they never challenged the sale deed of the year 1972 at any manner. So in absence of challenge to the our sale deed by a rightful owner, may be in excess. Whether the Learned Appellate Court is easily assigned, since my sale deed does not mention any partition, and partition deed exhibit 3 does not mention this fraud in 1979. Therefore, I failed to prove my claim. This is perverse. Whether the findings of the Learned Appellate Court are perverse on the face of exhibit 1, 3 and 4, coupled with oral evidence. And no reason has been assigned as required under the reverse the findings of the trial. This will be the proper question. Small a. And small e.
Appellate court का finding कौन सा पड़ेगा?
जी जी para 17. I have gone through the word
हाँ वो
नीचे
तो
पढ़ो. From the perusal of exhibit 4, now the pursuit. It is apparent that the suit land along with other land is recorded in the name of 3 brothers. And as per the plaintiff's case, partition took place in the year 1979. And in the said deed, there is no whisper about the suit land or khata or desa. The total area of such and such is 7 decimal, and as out of 3 brothers, 1 brother died shoeless. Hence, branch of 2 brothers got half and half share in the property unless any specific partition took place among the branches of 2 brothers. The plaintiffs have brought the sale deed executed by June number 1 in the year 1994 showing that there is prior partition and parties are living separately with the land. We ground number E also given. It is not in dispute that the execution of sale by parties in sometimes, this is presumption, showing separation, but it is not conclusive proof of partition. In this case, the sale deed of the plaintiff is of the year 1972, whereas the sale deed of the defendant exhibit 1 by E is of the year 1994. And as per the plaintiff's case, the partition took place in 1979. Hence, this sale deed will not help the plaintiffs in proving the partition. अगर 79 में partition हो गया तो 90
Or the learned counsel appearing on behalf of the applicants. The learned counsel for the applicant has submitted that as per the learned trial court, the plaintiff had duly proved exhibit 4 as is recorded in paragraph 25 of the trial court judgment. The plaintiff had duly proved exhibit 4 that it was recorded in the suit land was recorded, that the land in question and other lands were recorded in the name of Hemraj Pandey, Govardhan Pandey, etc. And they proved that the suit land came in share of Natho Singh in partition between Natho Singh and his brother Dwarka Singh. By exhibit 3, Natho Singh transferred the suit land. By exhibit 3, which is
exhibit 1
sorry.
17 वाला कर नाथो सिंह जाम को पूछे
Okay, by exhibit
1
by exhibit 1, Natho Singh executed in the year 1972. Natho Singh sold 7 dismal of land and Jamabandi was also opened. He submits that the defendants had executed sale deed in the year 2014, which was marked as exhibit 1 by A, and the same was for a portion of the property which was covered by the sale deed of 1972, and the learned trial court held that the subsequent sale deed dated 24/9/2014 was fake and forged document and executed without any basis, and the earlier sale deed dated 17/1972 was a valid document. He submits that the learned appellate court has reversed the decree, judgment and decree, and has recorded a finding in paragraph 17 of the appellate court judgment that there was no evidence regarding previous partition, and there was nothing to show that Natho Singh had got authority to execute the sale deed for the entire suit land, and consequently held that Natho Singh had the plaintiff failed to prove his case over the entire suit land, and reversed the finding recorded by the learned trial court. The learned counsel submits that as a consequence of the judgment passed by the appellate court, the subsequent sale deed dated 24/9/2014, which was in relation to the portion of the property which was covered under the sale deed of the year 1972, got validated, although the defendants had never challenged the sale deed of the year 1972.
Defendants or their vendor, Dwarka.
Defendants or their vendors never challenged the sale deed of the year 1972. The learned counsel submits that the appellate court has held the sale deed of the plaintiff as illegal and declared the sale deed of the defendant as valid. ये last sentence. The learned counsel has submitted that unless the sale deed of the year 1972 was challenged by the defendant by instituting a suit, the sale deed of the year 1972 was challenged by the defendant by instituting a suit, the same could not be held to be invalid by the learned appellate court. यही है? मतलब कौन सा क्वेश्चन ऑफ लॉ बता रहे थे? He has referred to
small a below. Small a that is with regard to reversal. Small e, where the possession is 1972.
considering the aforesaid submissions, this second appeal is admitted for final hearing. On following substantial question of law. Question number E कर सकते हैं?
जी
Question number E कर दीजिए. It will be open to the parties to it will be open to the parties to get additional substantial questions of law once the records is received from the court concerned. Let notice be issued to the respondents for ordinary process for which recusals be filed within a period of 10 days. Let the records be brought forth from the concerned court. Let the matter be posted on 27th of March. देखेंगे कुछ और हमको substantial question of law समझ आएगा तो हाँ properly नहीं बना हुआ है. हम देखेंगे कुछ होगा तो हम कर देंगे.
Hospital case item 7, second appeal 81 of 2022.
बहस करिए.
Also, purchaser and seller are both close relative.
ऐसे नहीं बहस करिए ना. Judgment of confirmation है, reversal है, क्या बहस कर रहे हैं? You argue your case? Yes.
I have lost the suit. Trial court. Appeal also.
So there is a judgment of confirmation. You are the plaintiff.
Trial court.
So
Without giving the consideration amount, salary has been disputed. कोई मेरा केस में कुछ पैसा नहीं मिला, ट्रांसफर के लिए, जो कोई चीज़ साला है, रिलेशन में purchaser and buyer, तो फिर मैं salary has been disputed और मेरा पैसा नहीं.
पढ़िए plaintiff का केस पढ़िए ट्रायल कोर्ट जजमेंट से. Appellate कोर्ट जजमेंट से पढ़िए. What was the relief? What was the suit for?
Suit was filed for declaration of title and cancellation of document against the defendants.
Without consideration.
No, sir.
What is the finding of the learned court? There is a consideration of everything. You see, you have made contradictory statements. The plaintiff mentioned in para 4 of the plaint that the defendant assured to the plaintiff to pay total consideration money of rupees 12,000 subsequently. In para 6 of the plaint, it is mentioned that the defendant assured the plaintiff to pay the balance consideration amount at a later stage. क्या मतलब है इसका? Yes. The deed itself is showing that you have received the consideration amount.
But actually the amount was
Actually मतलब क्या? यहाँ पे second appeal में ये actually क्या ही चलेगा? Yes. The deed itself is showing that you have received the consideration amount. बताइए? Mutation हो गया, सब कुछ हो गया. Paying government rent receipt. पंचायती भी हो गया आपका. Relative होने से क्या हो गया relative? The consideration amount is mentioned in the deed itself. Receipt of consideration is mentioned in the deed itself.
Therefore, I suited certificate, I said equivalence of the defendant not paid consideration amount of the said.
तो आपका केस है ना? Defendant admit किया है क्या कि नहीं दिए हैं पैसे?
Further stated that he not received consideration amount so that he not gave possession to the defendant or the suit. That the defendant certainly claiming the suit and in April 2009. The defendant claiming the suit and so that he has filed suit for the cancellation of CLP number 650 dated at IC Govarch. Lastly, he stated that his claim is right and the claim of defendant is wrong. Because the stated that the defendant is his brother-in-law, Manoj. Yes, he was stated that he was required when said deed was
नहीं ये इतना scrutiny of evidence नहीं हो सकता ऐसे. Permissible नहीं है. Law does not permit. सुन लिया.
Respondents को अगर सुन लिया
नहीं ऐसे नहीं सुन सकते. Respondent को तंग भी नहीं कर सकते. Or the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant submits that the appellant is the plaintiff in the suit and has lost in both the courts. He has submitted that still a substantial question of law arises in this case as the sale deed was executed without consideration and therefore it was null and void. The learned counsel has submitted that the buyer and purchaser, the plaintiff and defendant are close relatives, and the deed was executed without receipt of the consideration amount. And when the consideration amount was not paid, the plaintiff filed the suit seeking cancellation of the sale deed. After hearing the learned counsel for the appealants and upon going through the unit judgments, this court finds that the learned trial court claims specific issue, that is issue number 7, as to whether the sale deed number 650 dated 28/1/2006 executed by the plaintiff without receiving consideration on assurance of its payment in future, and is therefore said document liable to be cancelled on account of non-payment of consideration of money by the defendant. The further related issues were issue number 8 and 9, which are as follows. ये तीनों इशू को कोट कर देंगे ट्राई कोर्ट के जजमेंट से. इंटरनल पेज 4 है ट्राई कोर्ट के जजमेंट. The issue number 7, 8 and 9 were taken up together. And the learned trial court, after scrutinizing the materials brought on record, decided the issue against the plaintiff and in favor of the defendants. By holding that the sale deed number 650 dated 28/1/2006, it could not be said that the plaintiff executed registered sale deed number 650 dated 28/1/2006 without receiving consideration money. The learned court also considered that the registered sale deed, which was marked Exhibit one and Exhibit A, showed that the plaintiff executed the deed after receiving the consideration amount of 12,000 and also handing over the possession, and thereafter the property was mutated. And the defendant was in possession of the property. The learned trial court also considered the inconsistent pleading made by the plaintiff. The appellate court also scrutinized the materials on record and gave concurring findings and dismissed the appeal. This court is of the considered view that both the learned courts have referred to the materials on record and gave concurrent findings with regard to payment of consideration in connection with the sale deed. This court finds there is no substantial question of law involved in this case. Accordingly, this appeal is hereby dismissed.
Evidence should not be recorded. There is evidence for it in which the plaintiff clearly stated, मैंने क्योंकि प्रतिवादी हमारे संबंधी हैं विश्वास करके जमीन की कीमत बाद में लेने की बात स्वीकार की। मैंने तकरारी जमीन के दखल प्रतिवादी को नहीं दिया। बात कह रही कि जमीन की कीमत प्रतिवादी को जमीन का दखल देंगे तब देंगे।
दखल तो हो गया उनका डिफेंडेंट का।
दखल ये तो गलत आ रहा है इनके
गलत कैसे आ रहा है?
और मानव ने
दखल पूरा म्यूटेशन हो गया, सब कुछ हो गया।
ये ऑफ द ट्रांसफर ऑफ प्रॉपर्टी एज मानव ने कंडीशन
नेक्स्ट केस,
देयर इज प्रोविजन ना
नेक्स्ट केस रजिस्टर सेल डीड से ट्रांसफर कर दिया, सेल डीड में लिख दिया, पूरा पैसा ले लिया, उसके बाद उसका कैंसिलेशन चाहिए, म्यूटेशन हो गया, सब कुछ। ऐसा होता है।
Item 70 from Regis, first appeal, what is the of money?
Yes.
This is the first appeal.
Admit हो चुका है ना? चलिए, next. You are the, what was the suit for?
Suit is for declaration of title and for confirmation of possession.
What according to you is the point for determination?
Actually, some points are required to be considered, which are legal issues. My case is that for Balbhadra Mandal, who was our ancestor, in the Abdul settlement way back in 1927, the land was recorded in his. As per the admitted documents, it was a service to Chakran land.
What is service to cost?
Service to you, like person who rendered service to Raja.
He is allotted something.
It is allotted. It
He
is a
does not
service.
become a tenant.
I will come to that. And so our case is that after death of the Balbhadra Mandal, we have remained all along in touch. And in the year 2011, when they came to the land for doing some measurement, etc., then it came to their knowledge that the Regional Survey of Records Rights, Bhimsen Mandal and another person who are the heirs are defended. It has been recorded in their name. Thereafter, we have filed this. So far as the defendants are concerned, their claim is that they admit that it is a land in the name of the mother land. They say no, it was a senior service to the Chakran land. And their case is that in the year 1954, widow of the Balbhadra Taru Mandalai, along with her minor sons, she disputed Prajali Patta with the consent of her. That what is their claim. And they say that by virtue of that Patta,
You see, it will not be, it cannot be decided like this. Let us take the case of each one, right? Case of the plaintiff.
yes.
You just
I
narrate
was
the.
coming to legal issue. Let me say
Okay,
what
fine.
legal
All right,
issue.
all right. Okay. Let us just see the conclusion.
Okay.
Yes.
Mary.
The suit for was for permanent injunction.
It was for declaration of fact and for confirmation of position.
Possession.
And also that the user survey entry in respect of suit line is wrong and for permanent injunction. This was deliberate. The Paraman itself very clearly says that the subject matter of this suit is 0.72 decimal land situated in Moja Bhukuli, PS Saraikal, within jurisdiction of this law. The said land has been more fully described in Schedule A below, and hereafter referred to as suit. That during the cadastral survey of 1925-27, commonly known as Abdul settlement carried out under the authority of Raja and ruling chief of erstwhile estate of Saraikal was recorded in the name of Balbhadra Mandal, father of the plaintiffs, in the CS Khata 61 of Bhajar. That Balbhadra Mandal died 60 years back, leaving behind his widow Tarubala and the plaintiffs. At the time of death of Balbhadra Mandal, the plaintiffs were in early childhood. That on the death of the Balbhadra Mandal, the entire interest was inherited by the plaintiff through their natural guardian, Mother Tarubala, including the interest involved in this plan. That plaintiffs, through their mother, coming on possessing the entire land recorded in CS Khata number 61 of Mother Puli, and on death of their mother and plaintiffs are coming on possessing the land. That in the second week of November 2011, on the day plaintiff found that the defendants 1, 3, 5, and 6 are taking measurement of the said land, Sue and me. The plaintiff protested to their such act, but they told that during the last divisional survey, the suit land has been recorded in the name of their father, and they are going to sue the land. So the plaintiffs, astonished on their such utterance, at no point of time defended or their father ever opposed the suit land. That on such utterance, the plaintiff made search in the records room regarding the divisional survey record, and final publication of which was made in the 1964 with respect of the suit, and found that the said survey record the suit land has been recorded in the Bhimsen Mandal and the Kailash Mandal in RS
Bhimsal Mandal and Kailash Mandal are the defendants.
Yes, their descendants, their descendants are us. The plaintiff begged to submit that recording of suit land in the name of Bhimsen Mandal and Kailash Mandal is apparently wrong, erroneous. In such as much neither Balbhadra Mandal nor the plaintiff ever made any transfer in the name of Bhimsen Mandal and Kailash Mandal at any point of time. They always this would have been elected. That the plaintiff further begs to submit that during the last divisional survey, the plaintiff were merely boys of tender age and did not have any knowledge of survey matter. That aforesaid Bhimsen Mandal died 28 years back, leaving behind 4 sons, Vasudha, Yodhya, Vasisht, and Yodhya. Out of 4 sons, Vasisht died, leaving behind his son, Vasudha, Yodhya, and Yodhya, figuring as the defendants in 2023. Now, Mandal, son of that Vasishtha, Mandal is figuring as the defendant in the suit. Kailash Mandal, brother of the Bhimsen, also died 25 years back, leaving behind 3 Nirvan, Amulya, Santosh out of 3 sons. Kailash, Amulya has died, leaving behind 2 sons, Luna and Umakant, and Luna, Nirvan and Santosh, sons of Kailash Mandal, as figuring as the defendant numbers 5 and 6 in the suit. The defendant number 7 and 8 are the sons of the deceased Amulya of Kailash. 20 claims to submit.
That's it, these are all ornamental.
Yeah.
What was the defendant's case?
Defendant's case,
Defendant number 10 to 16, who were defendant number 10 to 16? They were added.
written statement has been filed by them. apart from
I see the defendant number 10 to 16. What about others?
others are also filed, but more or less stand is same.
17.
This sets
Which written statement should I read?
main.
Main is
It is 12th of March 2012.
by defendant number? Defendant number?
Defendants they have Vasudev Mandal है.
एक तो हमको WS दिख रहा है डिफेंड नंबर 10 to 16 उसके पहले कोई WS दिख नहीं रहा
Vasudev Mandal, son of that Vishal Mandal, defendant Burman, this would be a very
नहीं, ऐसा तो नहीं दिख रहा।
Vasudev Mandal is
इसको जरा देख के बताएंगे थोड़ा देख के बताएंगे इसमें से बताइए
defendant अलग अलग दिया हुआ है.
राइट एविडेंस दिखाइए ये सारे रिकॉर्ड आपके पास है आपके पास है WS का कॉपी
हमारे पास में अलग अलग डिफेंडेंट का है.
आप ये कौन सा रेफर कर रहे हैं वो आपके पास है बताइए
ये नंबर रिटर्न स्टेटमेंट फाइल हुआ है.
वो है ना सेम है ना
हाँ.
आप प्रोवाइड कर दीजिए क्या होगा इसमें नहीं है तो क्या करें ऐसा तो नहीं होना चाहिए सर्टिफाइड कॉपी आपके पास सादा कॉपी आपका पूरा रिटर्न स्टेटमेंट तो कोटेड है ना पैराफोर में ऑलमोस्ट ही कोटेड है पैराफोर में है ना तब तो उसमें तो कोई डिस्प्यूट नहीं है तो उसी से हम लोग रिटर्न स्टेटमेंट पढ़ लें है ना पढ़ सकते हैं ना? इंक्लूड ऑर्डर जजमेंट से क्योंकि इसके लिए इस केस को एडजर्न करना सही नहीं। Ready? Case of the defendant. वैल्यूएशन पर अलग से ऑर्डर होगा। You read the case of the defendant. The suit land was recorded in the name of Balbhadra Mandal. Read it from here. Para 4.
In case of the defendant, briefly that suit is not also what valuation also what suit is also what for non-order of necessary party as well as the defendant and transfer decimals lot number 395 year 94 presentation of the suit lot number Arunachal Sahu son of Charan Sahu Aruni is the number for construction of by the registered date 6/3/2022 possession and the suit is included but the site of the Karavala Asma will be valued at more than 3 lakhs.
Dependency.
It is further case of the defendant that the claim is not required and is affidavit according to law so that same is liable to be related as well as the receipt will file the suit by execution of true facts and liabilities. It is the further case of the defendant that the suit land was recorded in the name of Bal Mata 61 of village Kuli, but the plaintiff has suppressed the fact that the suit land was wrong and the recorded in the Jharkhand right in the name of the father used to render service to the landlord of Raja Saraki. And after the death of Balbhadra Mandal, there was nobody in the family to render the service to the landlord to provide the service land. And after death of Balbhadra, the widow Taru Mandalai, on behalf of her minor sons Sukhil Mandal and Ali Mandal, Patta, dated this the Chauvin, duly approved and sanctioned by the Pratap Singh of Saraki. In favor of that, the Mandal had elected the last Mandal, the predecessor of the Senate, respect to old plot number 193, 194, old number 61, and the settlers got possession over the suit and thereafter the Jari Application Act, the predecessor of the of the settled land and possessed the same in one right. Thereafter, the divisional survey under section and CIT was carried out by the state of Bihar, which has started from 58 and the final reports of rights were published in November 1961, wherein the state survey the land of old plot number 193 and 94 of Khata number 61 were made into new plot 391 and 95 and model in new Khata 94 in the name of himself Mandal and Kailash Mandal with 6 of it is further case of the defendant that the Bhim Singh Mandal died in 1996, leaving behind his 3 sons, defendant number 1, the widow, and a son and a daughter of predeceased son, deceased mother, daughter Ilavati, sister and left his widow, Matangini, daughter Draupadi, and a son, namely Ramchandra. The last Mandal died in the year 1998, leaving behind his sons Nirmal, Sarpos, Amelia, and daughter Vidubati, Devaki, Devaki, his son Amelia has left behind his widow Matangini, and a minor daughter Rekha, and two sons, one Kant and Rina, who are the dependent of 5 and 6 issued. The name of the widow of the deceased Bhatta and his daughter Draupadi and minor son late Mundya Bhatta and the married daughter of late Kailash Bhatta have been included by Plenty when after Plenty had ample knowledge about the correct survey according to the issued land and they never hesitated the demand for the settlement authority and the revenue authority as the permanent beneficiaries to voting on policy issued land is it is the further case of the defendant that the plaintiffs have full knowledge about the transfer of 7.5 decimals of land by the defendant house to suit land in favor of National Saru of the registered city, but neither he has been made party nor is registered city has been challenged by the plaintiff. Accordingly, plaintiffs have no right over the suit land and never possess the same under the defendant of the suit land. Having the right and paying to the state government regularly. Survey report of 1961 is correct and according to the facts. The plaintiff after the long slumber has no right to challenge the same and the claim of title interest and receipt of the land and false and bogus case. The plaintiff were duly represented and put down before the guardian mother before recordings. It is further news of the defendant that Bhims and Mandal died in the 96, whereas Raghunath Mandal died in the 98, leaving behind their heirs and successors, the Sudaland which formed by the side of Sudhamila Khatun. Main road has agreed great importance in view of the road for the industrial activity and municipality. Plaintiff out of dire greed and the instances of evil complex or village plan, find the suit to take a false claim on the Sudaland. Plaintiff never acquired any interest in the suit that especially on the grant of Rajali Patta on behalf of them by others, with due permission and approval of Raja Pratap Singh and Adit Pratap Singh Dev in 1954 and survey recording thereafter were directly made in the name of predecessor of the government with respect to suit. There is no cause of action to suit or to
That's right, you have seen there is evidence that the entry in record of rights also attained finality. It was never challenged.
That is correct. But that is my case. That way back in 1927, they are also admitting that it was in the name of Balbhadra Mandal and the Chakra. Now, and after death, our case is that we have no possession of it. When they interfered, tried to interfere, started to be development, then we came to knowledge that this land in the original survey had been recorded in there. Accordingly, we have filed.
Did they dispute your possession?
I will ask them the question that their entire claim is based on Rajali Patta. Rajali Patta had to be scrutinized by widow of the Balbhadra Mandal, along with her minor sons. They said that in the year 1954, that is also an exhibit, which is in the real life, my learned friend has vividly translated for the Abdul settlement record, which is also in the Odia language. We have also supplied the translated to show that the land is Chakra. I told this.
You see, the land, original land was in whose name?
Balbhadra.
Balbhadra.
They are also admitting it.
Balbhadra Mandal was a Chakran.
He was a Sikh Lordship may say. He used to render service to them.
No, राजा का नाम है.
राजा का काम था प्रधान नहीं
आदित्य
रामचंद्र राजा का नाम है श्री उदित नारायण सिंह 1927 में अब्दुल सत्तर
नारायण सिंह देव.
उदित नारायण सिंह
उदित नारायण सिंह देव.
there he was the ruler at the relevant point
ठीक है. चक्रान हुआ 1927 में.
इसमें चक्रान में 1920
In name of बलभद्र मंडल.
नियम ऑफ बलबल
माय लॉर्ड राजा उदित नारायण आदित्य प्रताप सिंह जो
ना उसका लौट
ये पेज 17 में देखा जाता है.
हमारे पास तो जितना महाराजा उदित नारायण सिंह देव के लड़का है आदित्य प्रताप सिंह. कभी
बलभद्र मंडल ये फेवर में चक्रान होता है.
he was the Chakma. Now they are saying that
What you are saying? पहले अपना कहानी बताइए. आप बलभद्र मंडल के डिसेंडेंट्स हैं.
हाँ हमारा इसमें मौजूद है वो भी तो पॉइंट है.
हाँ एक सेकंड. इनका क्या कहना है?
इनका बस जो है परजली पट्टा.
रजली पट्टा कौन एग्जीक्यूट किया?
और परजली पट्टा बलभद्र मंडल की वाइफ दादू मंडल है. my mother and for us for both the plaintiffs.
बलभद्र मंडल and her sons.
Plaintiffs.
Right? They executed what?
They executed a Rajali Patta.
Rajali Patta. What is this?
It is a simple unregistered
हुक्मनामा type.
इसको नहीं इसमें हुक्मनामा इसको इसलिए नहीं करेंगे क्योंकि she has no right. Admittedly she has no right.
At that point of time,
At that point of time,
the Raja was alive.
Raja was, and there clearly that
With the consent.
with the consent of that his signature, they have also filed that he is there. My question, I am putting a question to myself. Whether Raja was competent at the relevant point of time to give
Yes.
consent.
What is the date of this particular?
1954.
इससे क्या ही मतलब है?
Initially,
वेस्ट कर गया है तो.
initially, my lord, the Sulbu area, that Saraikela Khasama area, it was in the Odisha. It was initially in the Odisha. Thereafter, at the time of accession of those states, there was some agreement between the Union of India and the North that agreement had in place. Then, this area, Saraikela Khaswana area, it came in the state of Bihar. Relevant at the relevant point of time, this Raja Adil Pratap Singh there, he has challenged all those things. And later on, the matter was before the even constitution of the our 1950 the Supreme Court. It was before the Privy Council. Subsequently, matter was before the Supreme Court, and later on in the year 1963, Patna High Court decided, that notification is correct.
What is the date of that?
That notification, that exactly whether it will apply to these lands or not, that I will have to verify because there are certain changes. It is Burkuli, it is Burkuli.
See,
But
we
what
don't
I mean to
argue
say-
anything which is not born out of it.
No, what I want to say.
Because we cannot just take fact from other judgments and then put it.
No, I am not. What I am saying, I am on 2-3 points. First point is whether there, even if there, I assume there was a part, whether the Raja at the relevant point of time was competent to give sanction. That is the first issue which I want to raise. Second one, so far as the Chotanagpur Tenancy Act is concerned, in the year 1951 by Kharasama law, the Lordship may kindly see Saraikela and Kharasama Law Act 1951. CNT was applied to this act. With certain modifications. I would like to place section 77. Firstly, I would like to place what
You see, things you have not joint issues on this, particularly with respect to CNT. That much I can understand with regard to the competence to execute the patta.
Yes.
But with regard to CNT, these things are not there.
What?
We will, that the CNT was made applicable.
No, those things are relevant. I'm coming to that.
Relevant.
Your Lordship, may kindly see
No
first
such
section.
pleading to that effect. It was covered by CNT, the CNT was applicable, this
No,
land was
CNT,
covered
it is
by.
applicable. It is applicable.
We do not know.
No,
How
I
do
am
you say that it is applicable?
I'm saying.
You can say your words will not.
No, I'm showing documents. In the year 1927.
Which document are you showing?
Let me kindly see.
नहीं वो सब नहीं ऐसे नहीं हुआ ना.
आप इस पे
कोई भी प्रॉपर्टी सीएनटी
नहीं,
से कवर्ड है कि नहीं है.
सीएनटी अगर कवर्ड नहीं होता तो इनका रिविजनल सर्वे कहाँ से आ रहा है? पहले तो 1927 में ऑटो सेटलमेंट हुआ, उसके बाद जब ये लॉ आया 1951, तब उसके बाद सर्वे उर्वे का जो पुराना सर्वे था उसको इस सर्वे में माना जाएगा और इसमें से बाकी जितने भी जो कि प्रोविजंस हैं, कौन से प्रोविजंस इसमें विच मॉडिफिकेशन अप्लाई करेंगे, इसका सराय जिला एंड खारसाबाद लॉज एक्ट 1951 में इसको दिखा दो.
इसमें नहीं.
है.
तो आगे क्या बोलना चाहते हैं इससे? उसमें निकाल दीजिए बस. So what do you want to say by virtue of that?
I want to say, section 77, it talks about this
Talks about
question.
first.
And by virtue of that law, 1951, which I was showing, what was in the earlier one?
देखिए ये सब हमने नया कहानी ये सब नहीं सुनी. Because it is not a pure question of law. It requires a lot of factual background also. First of का background आप ले रहे हैं. आप इस एक्ट के
क्या लॉ अप्लाई करेगा? हम एप्लीकेशन ऑफ लॉ.
Yes.
हम एप्लीकेशन ऑफ लॉ. हम पहला ये चाह रहे हैं.
First show me that ये जो particular है पूरा इस एरिया पर अप्लाई करता है.
हाँ, अप्लाई करें.
And पूरा ही एरिया पर अप्लाई करता
हाँ, और ये एरिया उसी एरिया में उसी एक्ट से उसका ये
है. ये उनकी किताब है.
उससे पहले था ही.
हाँ बताइए सेक्शन 77 में क्या दिखा है?
77 में हम डाल column 8 following provisos certificate provided that the area comprised within the subdivision of Sarai Villa and Khasama of the district of Singhu, the incident of such use or holding shall continue to be regulated in accordance with the provision of any law in force immediately before the commencement of Sarai Villa and Khasama
ये कहना चाह रहे हैं कि सर्विस शेड्यूल में सर्विस शेड्यूल हैज बीन सेट मैकेनिज्म दिया है सेक्शन 6 के तहत
If the service tenure is saved, then under such circumstances, if she has transferred the property,
that is what I am saying. 2 points are now.
we are at
2 points are now.
yes.
It is a service schedule as per the Abdul settlement. The Abdul settlement, it is and subsequent revisional survey, it has been recorded in there. It is admitted. I cannot deny. I am only saying that service schedule, that is नौकराना है और चौकीदारी चक्रा और मदती जागीरी सेक्शन 3 का प्रोवाइजर है।
Section 3, Bihar Land Reforms Act,
हाँ
notification vesting. Section 3 का कौन सा प्रोवाइजर?
सेक्शन 3 का सेक्शन 6
6 का प्रोवाइजर.
provided that nothing contained in subsection shall entitle the intermediary to retain possession of any नौकराना land or any land accorded as चौकीदारी चक्रा और गोदती जागीर और माफी गोरेती in the records of rights has already been accrued to the year before the date of this. हम इसमें ये कहना चाह रहे हैं नॉर्मल कोर्स में कोई इनहेरिटेंस सर्विस शेड्यूल का नहीं इस पर जरा लेकिन पर्टिकुलरली इस एरिया जब ये 1951 में वो लॉ आई और उसमें वो कह रहे हैं कि नहीं इसमें जो पहले होता था उसको हम माने तो हम जब इसमें शुरू से भी रहे तो इनका राजा का भी नहीं होगा राजा का भी कहाँ से होगा क्योंकि पोजीशन में हम हैं हम पोजीशन में और आज भी पोजीशन में हम हैं
बात ये कोई भी इस तरह का प्रॉपर्टी जो सर्विस टेन्योर है
जी
while the person is holding it as service tenure, can it be transferred by Raja to anybody else?
उसके लिए
Because he does not become a tenant.
कर सकता है लेकिन he should first resume it without there is no redemption document on it.
Presumption, क्या ही presumption होगा? He
नहीं, अगर आप-
is service tenure. He will say that you render the service to Mr. X.
नहीं ये सर्विस शेड्यूल का जो भी रेंडरिंग होगा
ये तो आप वो बहस कर रहे हैं जो टेनेंसी में होता है मतलब जो अगर मान लीजिए कोई रेगुलर
इट इज सॉर्ट ऑफ अ टेनेंसी
शॉर्ट ऑफ ए टेनेंसी
ये और
दो अलग टर्म है तो शॉर्ट ऑफ ए टेनेंसी कैसे
ये फ्री ही है फ्री है क्योंकि लगान जो है इसका वो सर्विस so it is a tenancy so the only point is whether it will go to the descendants अगर इस पॉइंट पर अगर descendants को नहीं जाएगा तो हमारा क्या राइट दैट इज द क्वेश्चन व्हिच आई वांट टू हम उसमें ये बताना चाहते हैं कि सर्विस शेड्यूल में इंटरमीडियरी का उनको जिसमें राइट है उनको हो गया उसमें वो रिटेन नहीं कर सकते खुद इनका बिहार लैंड रिफॉर्म्स एक्ट भी कहा
फिर से पढ़िए प्रोवाइस
हाँ ठीक है
पढ़िए
उससे पहले पढ़ते हैं
ठीक
certain lands in the khas position of the individuals to be retained by them on payment of rent as a year having occupancy rate on and from the date of vesting of all lands used for agricultural or horticultural purposes which may in khas position of an individual on the date of vesting including provided proprietors private land under a lease for a term of years or under a lease for years to years referred to section 116 of Bihar Tenancy Act. Landlords privilege land let out to a registered lease exceeding 1 year. Land used for agricultural or horticultural purposes and held in the direct possession of the land used for agricultural or horticultural purposes forming a subject matter of subsisting mortgage or redemption of which the intermediary is entitled. Sir, subject to the provision of 7A, 7B will be deemed to be settled by the state with such intermediary, and he shall be entitled to retain possession thereof and hold them as a real under the state, having occupancy rights in the subject of such land, subject to payment of such fair and equitable rent, as may be determined by the collector in the prescribed manner, provided nothing contained in this subsection shall entitle an intermediary to retain possession of a Maharana land or any land recorded as a Chokidari, Chakhan or Dorati Jagi or Mafid Dorati in the records of right had already accrued to a Rayat before the date of vesting. अगर कोई रैयत का कोई राइट अगर हो गया वेस्टिंग से पहले,
provided that nothing contained in this subsection shall entitle an intermediary to retain possession of any Nokrana land or any land recorded as Chokidari, Chakran or Goraiti, Jagir or Maligotri in the record of rights has already accrued to the Rayat. इसका क्या मतलब?
इसका मतलब यह है कि अगर कोई रैयत को अगर कोई राइट हो गया इस पर्टिकुलर
रैयत को क्या राइट हो गया?
राइट अगर पोजीशन से जो चीज गवर्नमेंट में वेस्ट हुआ है वो अगर कोई जिसमें रहती राइट तो गवर्नमेंट में वेस्ट नहीं हुआ सेक्शन 4 देखा
ठीक है नहीं हुआ है वो ही becomes a tenant of the government.
हाँ वो पहले राजा का टेनेंट था गवर्नमेंट का टेनेंट
मतलब बीच में जमींदार हट गया.
हाँ अब इसमें so far as this button is concerned इसमें चूंकि
Chakran land is directly the land of the zamindar.
it is the zamindari
Zamindar's land. So therefore, if it is land of the zamindar, then it will vest in the state.
it will vest in the state.
Yes.
But लेकिन अगर उसमें कोई रैयत का राइट हो गया
क्या राइट हो जाएगा रैयत का? रैयत का क्या राइट हो जाएगा?
रैयत
मान लीजिए कोई रैयती एरिया में कोई चक्रान लैंड है या मान लीजिए रैयत का कोई राइट उसमें हो चुका है तो रैयत का राइट होने के लिए तो टेनेंसी चाहिए ना.
वही तो हम कह रहे हैं सर्विस ड्यूटी है टेनेंसी है लेकिन वो अलग चीज है कि टेनेंसी इसमें लगान के तौर पर इसमें सर्विस.
देखिए ऐसा है कि जो टेनेंसी रैयत का होता है there is a marked distinction between the two.
I agree.
There is a marked distinction between the two.
I agree.
जो रैयत का टेनेंसी है, he is paying rent. He was paying rent to the जमींदार earlier. Now he will pay rent to the directly to the state. यही फर्क है जमींदारी evolution में. Right now, so far as Nokrana land and these kind of lands are concerned, this will become the private property of the zamindar. It will not. So this particular property will not acquire the status of a रैयती land.
नहीं लेकिन इसमें इसका प्रोवाइजो कहता है
नहीं हमको नहीं लग रहा है कि आप ऐसा पढ़ रहे हैं.
तो उस वो पॉइंट ऑफ लॉ
तो लग ही नहीं रहा. आप जो बोल रहे हैं वो इसके प्रोवाइजो से वो है ही
नहीं प्रोवाइजो है. जैसे इसमें नौकराना लैंड में कोई एडवर्स पोजीशन भी नहीं होता क्योंकि इट इज सॉर्ट ऑफ
एडवर्स पोजीशन कैसे होगा?
हम कितनों दिन से भी रहे हैं
परमिसिव पोजीशन है और सर्विस प्रोवाइड करता है.
परमिसिव पोजीशन है लेकिन
नौकराना लैंड में एडवर्स पोजीशन
लेकिन हमारा इसमें कोई कर कि इसमें जो राइट हमको जो कुछ भी राइट होगा जो कुछ भी राइट है बाय वर्च्यू ऑफ द बीइंग इन पोजीशन वो राइट हमारा बरकरार रहेगा आफ्टर वेस्टिंग. हम ये कहना चाहते हैं क्योंकि
nothing contained in this section shall entitle an intermediary to retain possession of any Nokrana land or any land recorded as Chokidari, Chakran, such and such in the record of rights has already accrued to a Rayat before the date of vesting.
हाँ तो इंटरमीडिएट के बारे में कह रहे हैं. इंटरमीडिएट को कोई राइट नहीं होगा Nothing contained in these subsections are entitled an intermediary to retain possession of Naukarana land or any other land recorded as Chaupidari, Chakran, such and such in the records of right has accrued to the रैयत before date of estate. अगर वो रैयत को कोई राइट हो गया तो उस पर्टिकुलर केस में इंटरमीडिएट को उसको रिटेन करने का कोई राइट नहीं. दिस व्हाट द प्रोवाइडर से हमारा कहना है कि उधर आएंगे रैयत हो.
इंटरमीडिएरी को जो वो राइट था कि वो उसका जमीन है, इंटरमीडिएरी को कुछ जमींदार को कुछ वैसा भी तो प्रॉपर्टी था ना जो उसका राइट है. देयर आर टू काइंड्स ऑफ लैंड. वन इज जमींदार इज ओनिंग इट एंड यूजिंग इट हिमसेल्फ, अवकाश. अब दूसरा लैंड है ये रेंट वाला, टेनेंट वाला. ठीक है, दो कैटेगरी हो गया. सो जो बकास लैंड है वो जमींदार रिटेन किया उसको इवन आफ्टर वेस्टिंग.
उसमें परमिसिबल लिमिट में था,
जो भी परमिसिबल लिमिट में था उसको रिटेन किया.
सरकार ने उसे दिया.
दैट्स राइट. उनको भी एक रैयत मान के उनको रिटेन करा के वो प्रॉपर्टी रिटेन हो गया. राइट. बट दिस पर्टिकुलर ये जो नौकराना लैंड है इसमें बोले हैं कि intermediary will not have any right over these kind of नौकराना land. Provided nothing contained in this. उसके पहले क्या उसमें तो नौकराना का कोई बात ही नहीं है.
इसमें तो कह रहे हैं certain lands in past position of interest to be retained on them.
This will not form a part of khas possession of zamindar. This नौकराना land will not form a part of khas possession of the zamindar.
लेकिन अगर इसमें कोई रैयत का राइट हो गया,
रैयत का कौन सा रैयत? आप तो रैयत है ही नहीं, आप तो नौकराना है. सर्विस टेन्योर.
दिस सर्विस टेन्योर हमारा ये हम
रैयत, द मीनिंग ऑफ रैयत इंक्लूड सर्विस टेन्योर. अगर डेफिनेशन ऑफ रैयत में है सर्विस टेन्योर भी तब आपका
अंडर रैयत को आते हैं.
अंडर रैयत की बात ही नहीं है.
और
ये अंडर रैयत का बात ही नहीं है. इसे
चक्रान और अंडर रैयत
नहीं, अंडर रैयत कैसे?
अंडर रैयत
चक्रान इज नॉट अंडर रैयत. रैयत इज कोई एक रैयत है, उसके अंडर में कोई रैयत है तो अंडर रैयत होगा. चक्रान कैसे अंडर? चक्रान इज डायरेक्टली अंडर द जमींदार.
लेकिन उसका सब्सटेंस नहीं है. सर्विस टेन्योर का मतलब होता है कि सर्विस टेन्योर के तौर पर लगान दे रहे हैं. लगान हम दे रहे हैं. जो सर्विस कोई सर्विस दे रहे हैं दैट इज भी लगान. तो इसमें सिंपल मेरा इसमें कहना ये है कि अगर हम पोजीशन में थे लगातार आज भी और अगर
रेंट दिए सरकार को, कलेक्टर ने रेंट आपका फिक्स किया नहीं किया ना, नहीं करेगा. नहीं करेगा
नहीं तो ये
बिकॉज़ इट इज वेस्टेड विद द स्टेट.
नहीं तो इनका कैसे
इनका कैसे?
ये प्रादेशिक पट्टा के आधार पे, ये प्रादेशिक पट्टा के आधार पर पोजीशन से रीडिस्ट्रीब्यूट राजा साहब का कंसेंट को लिखा है. राजा साहब को 1954 में उनको कंसेंट देने का पावर ही नहीं. और आज भी जब हम पोजीशन में हैं और जब वेस्ट अगर गवर्नमेंट
1954 में ये पर्टिकुलर लैंड राजा साहब का वकास जमीन में आता था या ये टेनेंसी में आता था, ये भी तो इम्पोर्टेंट है ना.
हाँ, ये लैंड तो चक्रान है जो रिकॉर्ड्स ऑफ राइट्स का. रिकॉर्ड्स ऑफ राइट जनरली
चक्रान जमीन में क्या? चक्रान इज व्हाट?
चक्रान सर्विस.
It is very simple. Nokrana is what? You think of a very small dwelling. You have a house, you have a room, and you have given it to the servant to stay, and he in turn, instead of providing you rent, is giving him service.
No, this is the land.
उसी तरह का analogy है. Right?
लेकिन लगान इसको आप हमारा सर्विस को भी लगान ये इसका मतलब है.
कल सुनेंगे, पढ़ के आइए. कोई ऐसा तो नहीं है कि पहली बार आ रहा होगा. सर एक
इस पॉइंट पे जितने भी जजमेंट्स हैं, इसमें एक पॉइंट है जो इसको कंसीडर किया है.
अभी तक कोई ये इतना 1950 से लेकर अभी तक ये केस डिसाइड हुआ है. हम आपकी बात नहीं मान सकते.
होता है कि नौकराना रेंट में कोई रेंट नहीं है, ये हेरिटेबल नहीं है. लेकिन ये इस पॉइंट पे जो जितने भी लोग जो पोजीशन में हैं.
सुनिए मिस्टर शर्मा, आप अपने अगेंस्ट के भी जजमेंट्स लेके आएंगे.
हाँ,
सब लेकर आइए, क्योंकि अब तो यहाँ डिसाइड ही होगा ना, और इशू ही डिसाइड करेंगे कि उसके बाद बस सुप्रीम कोर्ट से ही सेटल होगा।
ये 2000
बिहार लैंड रिफॉर्म्स एक्ट का कोई अब पूरा पता नहीं है किसका इंटरप्रिटेशन।
जस्टिस तपन सेन साहब
हाँ,
का
बताइए।
कहते हैं कि नॉर्मल लैंड इनहेरिट नहीं, जजमेंट हम ला खिलाफ करते हैं।
बताइए
And I will show
बताइए
2004 volume 1 JCR
2004 वॉल्यूम 1 JCR
458 था।
458 Jharkhand.
बाबू मुंडा alias ब्लूटू मुंडा।
It has been affirmed ultimately.
इसकी परमानेंट तो नहीं कर सकते।
इसको check करो।
ये मोटा-मोटी ये लॉ है।
2004 1 SEC 456. इनहेरिट कैसे होगा? आप ही बताइए ना, सर्विस टेन्योर कैसे इनहेरिट होगा?
बात है कि सर्विस
Unless you get the status of a unless you get the status of a
तो हमारा जो है जो इस पे क्लेम
the matter, the arguments of this case has commenced. The matter has remained inconclusive. Close this case for further hearing tomorrow at 2:15. सुनेंगे कल एकदम अच्छे से, ठीक है? आप तैयार होके आइए। ये CNT एक्ट का एक मॉडिफिकेशन, ऑर्डर का डेट गलत।
वही रोक करा।
एक ही ऑर्डर है ना केस, और भी है। हाँ 250। दूसरा कोर्ट में मत चले जाइएगा, पार्टनर है, इसको करना है, ठीक है? शुरू करने के बाद हमको पेशेंस नहीं है। WPS number 1884 of 2020. The matter has been placed before this court at the instance of the office, indicating that the date of the judgment has been wrongly mentioned as 3rd of January 2024 instead of 3rd of January 2025. Reduce the records. Considering the office note, the date of judgment as mentioned in paragraph 2 of the final judgment paragraph 2 of the final judgment, which is order number 37, is directed to be read as 3rd of January 2025 instead of 3rd of January 2024. Office is directed to carry out necessary correction in the final judgment. और कौन सा ऑर्डर है? आइटम 4 फ्रॉम डेली लिस्ट कौन है इसमें?
आइटम 4 में substitution petition appellant when it is barred by 99 days thereby filed in limitation petition. IA number 12583 by 2024.
When did the appellant die?
Died on 15th February 2024. It should have been filed in 15th 2024.
Respondent कहाँ है?
appellant must
तो लिमिटेशन है ना, बिना लिमिटेशन कैसे कन्वर्ट करेंगे? बिना आधे से
नहीं नोटिस की
नोटिस तो करना जरूरी है ना। SA number 274 of 2023. Also, for the appellant is present, let notice be issued to the respondents.
IA number 12612 by
To the respondents on IA number
12612 by 2024.
12612 of 2024 and also in IA number 13470 of 2024. The requisites for service of notice under ordinary process be filed within 1 week, within 10 days. Close this case on 24th of March, awaiting service.